All right. Good morning, everyone. My name is Anne-Marie Drefke, and I'm the Education Manager for the Illinois Landscape Contractors Association. Welcome to our webinar today, Illinois' Anti-Harassment Discrimination, What Employers Need to Know, presented by Julie Procia with Smith Admonson. In August 2019, Governor Pritzker signed into law the Workplace Transparency Act. Illinois employers are required to train employees on sexual harassment prevention by December 31st, 2020, and on an annual basis thereafter. This requirement applies to all employers with employees working in this state. Employers must either develop their own sexual harassment prevention training program that equals or exceeds the minimum standards for sexual harassment prevention training outlined in Section 2-109B of the Illinois Human Rights Act, or they may use the model training provided by the IDHR. We are joined today by Julie Procia of Smith Admonson. Julie has given numerous valuable presentations on the Workplace Transparency Act and provided training for several companies. Julie will walk us through the act, what the training should include, and leave time for questions. Besides being a skilled attorney, Julie is also a great friend to the ILCA. She has been an active member of our Women's Networking Group, and she handles calls from our legal helpline. She has also done a number of webinars for us in the past on a variety of wage and hour-related topics. We can't thank Julie enough for her time today. Just a reminder that this webinar is being recorded. Therefore, we ask that all webinar attendees mute your microphones. Questions can be sent using the chat box and will be presented to Julie at the end. At this time, I'd like to present Julie. Welcome, Julie, and I'm going to transfer it over to you.
Thank you so much, Anne-Marie, and thank you, ILCA, for having me speak today. I really appreciate it. It is a pleasure to have the opportunity to work with ILCA, and it is a absolute pleasure to be able to speak with your members. Oh, sorry about this. To speak with your members on a variety of issues, including harassment and discrimination in the workplace. So that sounds a little ironic to say that it's a pleasure to speak about harassment and discrimination in the workplace. So with everything that's going on, this really kind of fell off individuals' radars for being a requirement for something that we have to do in 2020. And I've fielded this question a substantial number of times, we still do have to do so. So we're going to go into a little bit what the requirements are for businesses, and this is regardless of how big you are, whether you have 1 employee or whether you have 1,000 employees. These are things that we are required to do annually starting this year in 2020. So just a little bit of background first. So Springfield was really busy, and this all came out of the national and international Me Too movement. And what happened in particular in Illinois was there was a lot of controversy about the protections that were present, or frankly, the lack of protections that were present for individuals in the state legislature, and that they had nowhere to go if they were discriminated against. And then there was a lot of stories that came about individuals who worked for senators, representatives in the Illinois state legislature who made allegations of harassment but could not do anything about that. And that then spawned testimony and a year-long task force regarding harassment and discrimination, sexual misconduct in the workplace. I have the privilege of serving on the Illinois Senate Task Force on Sexual Misconduct as a representative from the Illinois Chamber, and that is the task force that helped craft the legislation that we're going to be talking about today. Most of the changes went into effect on January 1st of 2020. Some of the changes went into effect in June. So either way, they are all in effect now for all of the businesses and all of the entities that we're talking about. So everybody. So let's go through the major changes first. And then from there, we'll dive down a little bit into some of the some of the more nuanced things that we have to do. First and foremost, the changes to the Illinois Workplace Transparency Act, or the new Workplace Transparency Act, changes what we need to do with our employment policies and our agreements. And it requires that we cannot prevent individuals from reporting sexual harassment. We can't have things like automatic non-disclosure agreements or automatic arbitration clauses and non-disparagement clauses when it involves harassment or discrimination. This will require a lot of us to change our employment agreements, our severance agreements, and our handbook. Before 2020, harassment and discrimination you could only bring a charge of harassment and discrimination at the Illinois Department of Human Rights under the Illinois Human Rights Act if an individual was an employee. That was before January 1 of 2020. After January 1 of 2020, harassment and discrimination is illegal for contract employees. So if you have a temp worker, a day and labor worker, an independent contractor, they also now can file a harassment and discrimination complaint against employers, even though they are not traditionally employers for purposes of the rest of general contract law, so wage and hour law. The new legislation also clarifies that it is illegal to discriminate against an individual because of sexual harassment, but sexual harassment in the broader sense, gender, sexual orientation, that even if you are not part of that class, but are perceived as part of that class. And, you know, one of the things that I could share is that I've been practicing for about since 2003, so a number of years now. The most egregious case that I had was on a perceived sexual orientation, sexual harassment. And in this case, the individuals thought that the gentleman was gay and he wasn't. And because of that, because of their perception that he was gay, they proceeded to engage in harassment and discrimination. They thought that they were, or they defended themselves by saying that they were hazing the individual. And how they defended, and what they said is that they were doing boys will be boys thing. And this was in a part of the country that was super wilderness, super remote, and very, very snowy, very, very cold, you know, below zero. They were laying pipelines. And what they did was they wanted to man him up. And so that's them, not me, which is why I did it in air quotes in case you guys can't see me. They tied him to a tree, left him overnight, and the next morning when they found him, he had lost, when they were able to bring him to the hospital, he lost a couple fingers and a couple toes. And this was an 18-year-old kid. And it was because of the perception that he was gay. And so I represent employers. And so one of the things that the gentleman, and I kind of say that a little bit loosely, were trying to argue to me was, well, since he's not actually gay, I don't think that it should be we shouldn't be liable for this. And I was like, I don't really think I'm going to go before a judge and make that argument. I think that as a company, we are going to write a check. I think that's how that one is going to work. This takes that off the table, that argument off the table, that even if that person isn't in that class, you're just perceiving them to be, that they're protected. It also expands VESA, and VESA is the Victims Economic Safety and Security Act. And VESA is the unpaid leave that's similar to FMLA, but it's for gender violence. It's for individuals who are victims of domestic violence so they could take time to seek medical assistance, legal assistance, counseling. Prior to this, VESA was only for domestic violence. Now, this also includes individuals who are victims of gender violence. So if an individual is being sexually assaulted at work, that wouldn't have been included in VESA. But now with the expansion of VESA, an individual can take time off to go report it to the police, to go seek medical help. And this was based off of some testimony that employers would fire somebody when they came to work and said that their coworker had sexually assaulted them at work and they needed to leave early because they wanted to go report it to the police, go to the hospital, go to the doctor. And they would say, well, you don't have any time off, so you're being fired. So that was kind of the impetus of where that came from. Some of the other major changes is that now one union representative can't represent both the victim of harassment and the alleged harasser. They have to be given a separate individual so that one person isn't essentially playing both sides. It also requires that employers, whether they're labor organizations, units of governments, or private entities, disclose any final adverse judicial decisions of sexual harassment against the Illinois against them, where that happens anywhere in the country, to the IDHR once a year. And when we're talking about final decisions, adverse administrative ruling, that's when you go through a whole trial and then you get the decision, or you get a final administrative ruling. It's not you get the right to sue from the EEOC or the IDHR, and then they take the next step. And this is the big one, the next one that we're going to focus on a lot, that really impacts everybody. It requires employers to annually train every single one of their employees every single year on sexual harassment training. And these training requirements, for the landscaping industry, it's the general training. If we were different industries, and I left this in there because sometimes employers own multiple businesses and multiple spheres, have different components if you are also a bar or a restaurant or a casino. So for landscapers, we have to do training every single year for all of our employees. So now let's delve down, right? So let's delve down into the big three. And the big three are the limits on the confidentiality agreements and arbitration agreements, the mandatory harassment training, and the mandatory adverse findings report. These are the three things that are the big ones. So the first one is going to be the changes for our non-disclosure agreements, our arbitration agreements, and our non-disparage agreements. So a lot of times when people are offered a position, we give them an employment agreement. And that employment agreement cannot say that they have to do mandatory arbitration. Arbitration cannot be mandatory anymore. And it's void if it's considered mandatory. Individuals have to have the ability, when they sign that agreement, to opt out of arbitration. And we have to show that individuals actually do have the ability to opt out. Not that we just say that they can opt out, but that there are some people who do opt out. Nothing prevents us from doing arbitration as long as the parties agree, but it has to be an optional provision that they have. No agreement can prevent an individual, an applicant, an employee, a former employee, from reporting harassment or discrimination to a government entity, particularly criminal activity. What essentially that means, if somebody is sexually assaulted at work, we can't say that, well, you signed an agreement that says that you can't go report that to the police. We have to still let them report that to the police. For our agreements, for our settlement and severance agreements, a lot of times we'll work with our employers and we'll do a severance agreement or a settlement agreement, and we'll do one for them, and they'll use that, the following year or the next time that they've done it. So if you have a severance agreement that we've worked with you on in any time before January 1 of 2020, throw that out, and please, please, please don't use that, because the settlement and severance agreements are different now. They have to have very specific language regarding harassment and discrimination. They have to give individuals the ability to have a longer length of time to review an agreement. Prior to January 1 of 2020, individuals would, if they were over 40, they would get 21 days to review the agreement pursuant to the Older Workers Protection Act. But individuals who were under 40, we only had to give them 7 days to review the agreement and then the ability to, revoke. Now, everybody, regardless of age, regardless if you're, 70 or regardless if you're 19, you have to get 21 days to review the agreement and 7 days to revoke. If we violate any of these provisions, then it runs the risk of invalidating the whole agreement. And if the individual has to sue to invalidate the agreement, we are liable as employers for the attorney's fees and costs for that individual to go and contest it in court to get those provisions invalidated. So the big one, the big kahuna, so to speak, is the mandatory harassment training. This is something that we knew was coming because Illinois likes nothing more than being the little sister, little brother of California. So if you want to know what's going to happen in labor and employment laws, you look to see what California is doing, and then a few years later, Illinois will follow. And a couple of years ago, or a few years ago at this point, California mandated harassment and discrimination training for all of its employees. We just went that way as well. So starting on January 1 of 2020, all employers have to do mandatory harassment and discrimination training for all of their employees. By the end of the year, by December 31st of that year, everybody has to do harassment and discrimination training for all of their employees. The harassment and discrimination training has to include a number of points, and these are the 4 points it has to include. An explanation of what sexual harassment is, examples of conduct of what is unlawful sexual harassment, a summary of the federal and state legislation regarding what harassment is, and here's the big one, including remedies that are available to the victims of harassment. And when we're talking about remedies just aren't just things like you could take leave, you could go under VESA, but also you could get back pay. You could go to the EEOC and file a complaint of discrimination. You could go to the IDHR and file a complaint of discrimination. And a summary of the responsibility for employers in preventing harassment and discrimination. You know, we have to have a policy. We have to have an investigation process. How does the investigation work? What is the responsibility of our supervisors? That they have to do things if they knew or should have known that something was going on. And so it has to have this description. The presentation has to be about an hour long to be compliant. I recommend, as do my colleagues, that your presentation be blocked into 2 components or 2 different presentations. One for your employees and one for your supervisors and members of management. And the reason you want to separate the 2 is because for your supervisors and members of management in Illinois, we have what's called individual liability for supervisor and members of management and owners, for individuals who knew or should have known what was going on and did nothing about it. I really fall under the philosophy of that a little bit of healthy fear is not a bad thing. So for supervisors and members of management, I really want to drill this point home to them that, you know, if you see something going on, if you listen to everybody and they're making jokes or you're CC'd on the jokes and you don't do anything about it because you're like, oh, whatever, that's just Bob. Bob always does that. Or, you know, we're in a rough and tumble industry and like people just joke and everything like that. And we don't do anything about it, that they run the risk of being sued individually as well as the corporation, and that they could put their house on the line, put their canoe on the line, their car, whatever it is that's important to them. And I really kind of hammer on that in the beginning with the members of management and supervisors. Do not focus on that with the employees because, like, I don't want to give them any more impetus to, you know, to sue or to file a complaint. But I really want the supervisors, the members of management, the owners to understand that so that they take it seriously when they get any complaints or allegations. I can't do anything about what they did in the past, but we need them to take it seriously going forward. Let me stay on the model training for a second. So the model training, the IDHR, the Illinois Department of Human Rights, put out a model training for use. So the model training that is put out is good. I'm not saying it's not good. You could go on there, you could download it for free, and you could conduct the harassment and presentation and training yourself. Be careful because the model training goes into extraordinary detail about how to file a complaint of harassment and discrimination with the EEOC and the IDHR. And that's one of the things that is required under the legislation, right? Part 3 is that you have to do the summary of the remedies and the statutory provisions. It does not say how long you have to focus on it. So when other entities do the presentation, when we do the presentation, I'm assuming when other entities, HR professionals, attorneys do the presentation, we will give that information, but it is not something we stay on for 10 slides. So be mindful if you're using the model training, how much of an emphasis is being put on that. So mandatory reporting. Mandatory reporting begins on July 1st of 2020. And so So we are all under that now, right? So it's July 1st. And that every employer has to present, has to submit to the IDHR for the preceding calendar year all final administrative judgments. And while this is a big one, this will impact very few of us compared to the annual harassment and discrimination training, because the vast majority of us do not have a final adverse judgment or administrative ruling against us. Things very infrequently go all the way to trial, where there's a decision, whether it's on the administrative level at the IDHR or on the state or federal level in court. For the most part, these matters settle out prior to that, and settlements don't have to be reported. So this will impact us, but it will impact much fewer of the organizations and entities than will the training, which involves everybody. And again, the training involves everybody, regardless if you have 1 employee or 500 employees, regardless if your employees are related to each other, which sounds so weird, because for a family business, like, I'm pretty certain that I'm not going to sexually harass my kid or my sister, but regardless, you still have to do the harassment and discrimination training. And when and if you receive an EEOC charge or an IDHR charge, one of the first things that they're going to ask for when they're collecting information and data in their questionnaire and information sheet is, when did you do the harassment and discrimination training? Where is the sign off for that individual? What is your policy? And if you don't have that information, if you haven't done the training, you're already a knockdown against you. When we're looking at the mandatory reporting to the Illinois Department of Human Rights, remember, again, this is final and non-appealable adverse discrimination anywhere in the United States. It does not matter if it's an administrative ruling in South Dakota or if it's an administrative ruling in Illinois. And when we're looking at that, it's looking at all these types of harassment and discrimination: sexual harassment, basis of sex, race, color. It's not just purely sexual harassment. It's any discrimination or harassment complaint that you have a final ruling in an administrative or judicial venue that covers any of these discrimination, harassment, protected categories: age, disability, race, gender, military status. So while we don't have to submit an annual report to the Illinois Department of Human Rights regarding our settlement agreements, our severance agreements that we have with individuals, private settlements regarding harassment and discrimination, we don't have to submit that every year or anything like that. The IDHR can request that. So they're not just going to call you up like a DOL audit and stop in and say, hey, how many settlements do you have? But what they can do is when and if you have a harassment or discrimination complaint against you, and I say when and if, because at one point in time, regardless of how fabulous of an employer you are going to get a harassment and discrimination complaint against you. It's just the nature of doing business. So when and if one is filed against you, then they can go back and say, hey, have you settled any cases in the past 5 years? Or any private settlements? Somebody leaves and it's part of it, and they allege discrimination or harassment. And then because of that, you do a settlement agreement, that they could ask for that. And what they're looking for is, think of this as the Harvey Weinstein component of it, where it came out that there were, numerous individuals that alleged harassment against Mr. Weinstein, and that there were private settlements that happened prior to the final individuals that came forward, and although it was everybody knew it was going on thing, nobody was able to do anything about it because they were all tied up in these private settlement agreements, confidentiality agreements. And so if somebody filed a complaint of discrimination against Harvey Weinstein at the Human Rights Department in California or at the EEOC, they couldn't get the information because there were confidentiality agreements in place. And so now they're saying, we don't care. That person might have signed an agreement that they're not going to sue, but we need to know if there were 10 other people that this occurred with, so to see if that this is a pattern or practice. So when we're talking about VESA, again, VESA has been expanded to include gender violence. So VESA is the 12 weeks of unpaid leave, so that's why I said it's similar to FMLA, that individuals can have, but this is for under 50 as well, that individuals can take if they're a victim of domestic violence. You know, if they need to go to court in order to get an order of protection, if they need to go to the hospital to have a rape kit, if they need to meet with a sexual assault counselor to seek not just an order of protection, but to have alternate housing. This has now been expanded starting in January of this year to also include gender violence. And so that it's not just people that live in your household, but if you are stalked by somebody else, or if there's somebody at your work who is engaging in this type of behavior, that you have protections for this, that you won't get terminated, that you have a unpaid leave of absence so that you could seek assistance for that. So it is possible now for sexual harassment to trigger the VESA protections, including the leave mandate. In addition to the leave mandate, VESA also includes protections that are accommodations in the workplace. So it would be something like if the individual is alleging that somebody that they work with is stalking them, is physically assaulted them, that you would, as a reasonable accommodation, switch their shift, put them in a different, switch their shift if they ask their shift to be switched. Otherwise, you are always going to switch the shift of the respondent, of the alleged perpetrator, and not the alleged victim. You know, if they say that they need somebody to walk them to their car, or if they need to park in a closer parking spot because of something that's going on, these are reasonable accommodations that could occur. When we're looking at harassment and discrimination and the changes to the harassment and discrimination laws, we also want to talk about the Equal Pay Act. And the Equal Pay Act is separate from the harassment and discrimination laws, but really it kind of runs concurrent with it because it's something that was effective in September of 2019, and then something that really starts in 2020 that we need to look at. So under the Illinois Equal Pay Act, which was amended, equal work has now been expanded. So the very just like crux of what the Equal Pay Act means is that you will be paid equally for work. So that if you hire Beth and Sean to start work on June 1 and they have the equal amount of, they have the same or similar background, let's say they have no experience in the landscaping field, if they're all going to start out at $14 an hour minimum wage in Chicago now, or $10 an hour minimum wage outside of it, then we start them off on it that together. But that we don't start it off where it's one person's making, the male is making $17 an hour for the same amount of experience, and the female is making $11 an hour. And so that's just like kind of the baseline of what Equal Pay Act means. And you can see why it's like it's related to sexual harassment. And so how this was changed as well is that now it's substantially similar. So it's not that it has to be a direct one-for-one. It has to be substantially similar work or background or experience of why you're doing it. So you need to be able to defend. So, well, if I'm starting out Sean at $17 an hour and Beth at $11 an hour, why? What experience, skills, talents do they have that is substantially different as to why they're getting paid for other individuals? We also have to let individuals inquire about the wages or salary for other individuals. And excuse me, we cannot allow, sorry, I said it backwards. We cannot allow our HR directors, our hiring managers, our supervisors to ask about the wages or salaries of the individual. So what that means is, a lot of times in the past, you used to say like, well, how much were you making at your previous job? You cannot ask that anymore. Cannot, hard stop, cannot ask that. You can ask, what is your salary expectation? You can ask, what would you like to make? But you can't say, what were you making before? And then base your offer off of what they were making before. And the theory behind that is that because systemically, women have been paid at a substantially lower rate than men, 66 cents for every man's dollar for the same or similar work, and even less if you're a woman of color, that it just perpetuates it, because then you are giving the individual less money for the same talents and skills as another individual, and just keep on perpetuating that. So the theory is, if the job is worth $17 an hour, you're going to offer it to them for $17 an hour. If you're found to have asked the individual, you know, what their salary was in the past and base it off of that, then the individual, if they sued, can get special damages up to $10,000 per year. It's recoverable. And that's things like back pay. Like, okay, well, you offered me the position and you asked what I was making before. I told you that I was making $11 an hour, so you offered me at $11 an hour. You asked Sean what he was making. He said $17 an hour. He was offered it at $17 an hour, and we have the same or similar, you know, background and experience. But the only difference was I told you that I made $11 an hour. He told you that he was made $17 an hour. If the individual sued a year later, they could get the difference, that $6 an hour for every hour that they worked, including attorney's fees that could go up to the $10,000, which is recoverable. Again, nothing prevents an applicant from saying that, you know, I would like to make $15 an hour. That's fine. But you can't say like, well, what did you make in your previous position? You also, and this is kind of what I was saying before, but I didn't want to confuse everybody. Individuals can ask the salary of other individuals. You can't make it so that it is, a lot of times I used to see, I don't see it so much anymore, but a lot of times I used to see in employee handbooks where it would say like, you know, if you're discussing salary or wages or bonuses, you'll be disciplined, including termination. We can't do that. We can't discipline somebody for talking to their colleague and saying, well, what did you get for your bonus? They're allowed to talk about their salary information. Nothing prevents them from making wage or salary inquiries to their colleague. When we're looking at Equal Pay Act, we really need to look at doing a disparity analysis of our organization to ascertain, you know, if we are incongruent, you know, if individuals have the same or substantially similar experience and background, why one individual would be making more so than another individual. You know, if it's different, you know, like you're obviously going to pay somebody different if they come in with 5 years of experience versus somebody who came in with 30 years of experience. That's not what they're talking about. But if somebody's like, well, you know, this person has their bachelor's degree and that's why they're paid this, but this other person doesn't have their bachelor's degree, but they were finishing up let me back it up. Here's the example. Somebody has their bachelor's degree. They finished it in December. And so we were like, well, we'll start them at $17 an hour. And we're starting them on July 1. Another person is finishing up their bachelor's degree and they'll obtain it on July 15th. And they're also starting on July 1. That's substantially similar. You can't make the argument, well, they didn't have the bachelor's degree when we offered the job. Well, yes, but they did 4 days later. You know, so like you have to look at what's substantially similar. When we're looking at the IDHR, we have to look at, you know, there really were a confluence of changes that occurred for purposes of the Workplace Transparency Act. And one of the other things that became effective on July 1 of 2020 was that prior to this, you had to have 15 or more employees for everything except for sexual harassment, pregnancy, and disability in order to qualify as an employer for purposes of being sued. So our defense before was, well, we only have 7 employees, so this complaint has to get dismissed because we don't have any standing. We're not an employer for purposes of the act. As of today, as of July 1 of 2020, that is expanded beyond everybody. So it is not just pregnancy and sexual harassment or disability, but also for race and gender, military status, disability status, genetic information. It's every protection under the Illinois Department of Human Rights Act, or the Illinois Human Rights Act is expanded now. So it doesn't matter if you have 1 or 500 employees, every employer is covered now. When we do harassment and discrimination training, we do it so it encompasses both sexual harassment under the Act, and I recommend that this is how you do it, but also discrimination and harassment, because how you're going to be doing an investigation for purposes of a discrimination complaint, you're going to do it the same way, whether it's sexual harassment or it's an allegation of race discrimination. You're going to do it the same way. So we expand upon it, and I recommend that you expand upon it so that you're covering everything at once, so that you're saying things like, okay, if we get a report of discrimination, whether it's sexual harassment or race discrimination or any other protected category, these are the steps we're going to take. We're going to take it seriously. We're going to separate the parties if there's any danger or risk to anybody, so we're going to go through those as it's both, because again, this is applicable regardless if it's sexual harassment or any other discrimination or protected category under the Illinois Human Rights Act or under the Title VII, Title ADA, ADEA. Okay, so I want to go through a little bit now on how to conduct an investigation and how you need to do it to be compliant under the Act. Because remember, in the very beginning, I talked about the 4 things that you're required to talk about. And one of the things is your responsibilities as an employer. And one of your responsibilities as an employer is to conduct an investigation and how to neutrally conduct it. So I'm going to go through briefly for a few minutes on how we need to do this. And courts are going to scrutinize what we did from start to finish. We are not expected to necessarily get it right. We are human. So individuals can get it wrong. We can look at a set of facts and learn later on that we were wrong, that somebody was lying, that we didn't have that information. And that's okay. It's how did we do it? Did we conduct it neutrally? Was it a fair investigation? Or did we just essentially, code it over because that person has worked for us forever, or that person is the owner's son or nephew or cousin or whatever it is? How did we do it? So when we're looking at an investigation, there's some steps that we want to take. You're going to interview the complainant. What is their complaint? What is their, what occurred? What do they allege that occurred? What do they see as occurred? There is no requirement, and I've heard this many times, well, they didn't file a formal complaint. There is no requirement that they file a formal complaint. I do not know how that rumor got spread years ago, but there is no requirement. It's like the windshield time that used to go through the landscape industry years ago. There is no such thing. So if they tell a supervisor that they felt uncomfortable about something, or that they've been harassed or discriminated against, or that this person is leaving nooses in their locker, or pictures of porn, or whatever it is, that is a complaint, and we have to take that seriously. So we're going to interview the complainant. We're going to find out what occurred, or what they alleged occurred. And we're going to also interview the alleged harasser. What is their side of the story? If we need to, we're going to interview witnesses. And when I say if we need to, a lot of times you don't need to. I have done, so prior to obtaining my law degree in 2003, I worked at the Equal Employment Opportunity Commission. And then during law school, I interned at the Equal Employment Opportunity Commission. And then subsequent to that, I've always done labor and employment, and I've always represented employers. So I, a lot of times, will come in to my employers and do harassment investigations when they need somebody to come in to do a third party to come in. Like, let's say the allegation is alleged against the plant manager or the HR director, where you have to pull them out of it. So I'll come in and do it. So I've probably done a few hundred investigations at this point. The vast majority of them, when you talk to the harasser or the alleged harasser, they will admit that they did it. They will say, well, yes, I made that joke, but oh my God, I totally didn't mean anything by it. Like, we've been friends forever. I was joking around. And the reason that occurs is because you work with the people in your office, on your crew, 40, 60, 70 hours a week, depending upon where we are in the landscape season. You get to be really friends with the people and you get to joke, and that's okay. But then we take the joke too far. So when that occurs, when individuals are like, I totally said that, but I didn't mean it that way, I don't need to then interview 10 other people to find out if they said that. I know that they said that. So likewise, I don't necessarily always need to interview the complainant again. You know, if there's a discrepancy, if I need additional information, I'll go back to the complainant. There might also be additional information that I need in order to ascertain what happened. If they're alleging that they were sexually assaulted in the break room and we have cameras in the break room, I'm going to look at that information. If they're alleging that this person has been stalking them and we have GPS on our trucks, I'm going to look at the GPS on the trucks to see if they have been going there, if they've been using the truck, or if they've been making calls to them repeatedly and it's on our company phones. We can look at those records. So based off of that, you're going to look and see if there's any additional information that you can look at. And then you're going to make a determination as to whether or not the harassment occurred in violation of your policy. And you're going to draft an investigation report. And that's going to be a finding of that there was a violation of the policy, that there wasn't, that it's inconclusive. And a lot of times it's that there was not a finding of discrimination of the policy, but that the behavior was unprofessional, was bullying, was not harassment in the traditional harassment and discrimination sense under the protected categories of the Illinois Human Rights Act, or Title VII, or ADEA or ADA, but that it does not meet your code of conduct. And then we're going to speak with the complainant and the alleged harasser to let them know what the determination and conclusions are. We don't need to tell them. And when we do the harassment and discrimination training, I spend a lot of time on how the investigation works and I recommend that you do so, and what the levels of confidentiality are, because we want to set that up right away, that you can't come into somebody's office and just say, so I want to tell you about this, but I don't want you to do anything about it. This is not a bad episode of Forensic Files where somebody leaves a letter that's like, okay, so if I'm killed by my husband, then I want you to know, or if I'm killed, I want you to know that it's by my husband. No, we're not doing that. If somebody comes in and says, I want to let you know that this is going on, but I don't want you to do anything about it, I just want somebody to know in case something happens. No, once we know, we know. So, one of the things that we talk about is that investigations are confidential to a point. Complaints are confidential to a point. I'm going to try and respect your confidentiality as much as possible, but I have an obligation for the safety of you, the organization, and the health of the organization. So I'm going to have to, if you tell me that somebody has sexually assaulted you, I can't keep that quiet. I need to do an investigation. I need to find out what's going on. And I can tell you if there was a violation of the policy or not a violation of the policy, but not what happens next. And the reason that I say that is because you as an employer have an opportunity to do multiple steps of discipline. And this is something that's really important to convey when you're doing harassment and discrimination training. You could do anything from a suspension, which people will see if somebody's not there, at termination. Again, big steps. Everybody sees that. But you could also do things like mandatory one-on-one harassment training. And boy, oh boy, is it kind of fun and gets all my aggression out when I get to sit there for 3 hours and essentially beat up on somebody about proper etiquette and behavior in the workplace. You could do things like anger management counseling and training, substance abuse counseling and training. Nobody gets to see what they do. You can let them know that we took remedial actions, but not the scope and nature of them. And it's really good in your harassment and discrimination training when you're doing the mandatory training to highlight that, so that you could go back when somebody says, well, I want to know what happened, because people want to know, because right, wrong, or indifferent, they feel like something occurred and they want to know what happened. But it's good to set on the outset that they don't get to know everything. And we need to take prompt remedial action, meaning we cannot wait 3 weeks for it to occur. Because if we wait 3 weeks, then what happens is they go back and use those outside remedies. We want to be able to take it in-house so that people feel like we care as an organization and that we are going to address things so that they don't feel the need to say, they don't care what I said, like I said something, they're not doing anything about it. So screw this. I'm going to go over to the EEOC. I'm going to go to court and I'm going to go file a complaint there. I'm going to call up that 1-800-JINKY number that you see on the UPN at 2 o'clock in the morning. You have to investigate. It does not matter if somebody says, I need you to take off your supervisor hat and put on your friend hat. Once you know, you know. And that's one of the things that you really need to, during the harassment and discrimination training, really focus on with your supervisors and members of management, that once they know, you know. We cannot just say, well, that's just Bob, or they were just joking, or they didn't complain. Once we know, we know. We have to do something about it. Our liability clock starts once we know. If the victim asks us not to investigate, we have to explain that it's our duty. It's not just to that individual, but to other individuals within the organization or entity. And when I'm doing training, a lot of times I'll say something like, if you really don't want to know, if you're really just blowing off steam, because everybody, regardless if you work the greatest employer or not, has a moment where you're like, oh, they're so frustrating. But if you have that you're so frustrating moment, you need to complain about the frustration to your priest or your friend or your spouse, but not to your supervisor, because as a supervisor, once you say something to me like, this person keeps making all these jokes and it's driving me nuts, I know that now. I have to do something about that. You can't promise confidentiality, and that's something that you really need to stress, both in the investigation process as well as when you're doing the training, so that people really understand that. We're going to do everything we can to limit it. I'm not going to go around and say, hey, Julie filed a harassment and discrimination complaint against Scott. But that being said, I might have to investigate and talk to other witnesses. I might have to do that if it's a he said, she said, she said, she said, he said, he said situation, to ascertain what, if anything, other people heard or saw. When we're looking at questions, we want them to be open-ended. We want them to be kind of a mix of open-ended as well as general questions. Not, did you see Bob do this? But you break it down as, have you ever seen any distribution of any sexually illicit materials, any porn, any jokes, whether they're emails or cartoons or written or text or anything? Have you ever seen anybody do that? You want to go general without saying, have you ever seen Bob sent this? Because you want to go general and then bring it down to more questions. So you've never seen that. So you've never seen anybody do that. No. Never on text. No. Email. No. On PM. No. Nothing. Okay. So you've never seen Scott or Bob or Steve, anybody send anything like that? No. Has anything ever been sent to you like that? No. Have you ever sent anything to anybody like that? So you want to just keep narrowing it down. Think of your best, Perry Mason narrowing down any PD show you've ever watched type of thing. Always have a written investigation report. So what we do is I will take the statement from the individual, or I will do an interview, witness or complainant or respondent, and I'll write a summary, and then I'll send it to them and say, can you take a look at this and let me know if this is correct? If I missed anything, I was taking notes, I was going fast, just take a look, because I want to pin them down on what they say, so that if they do file a complaint or charge of discrimination in 2 years, and all of a sudden they bring up 40 other things, I'm like, that's not what they told me then. Look, they even initialed it that they did. And by the way, everybody likes correcting your grammar. Everybody likes adding something else. So they will write something on the sheet of paper. A well-drafted investigation report really will help you. It increases credibility. Look, so when you're saying and testifying, court moves slow. So if you're saying that, 3 years later, you're testifying that this is what they told you, you're not going to remember what happened 3 years ago. But if you've got a well-drafted investigation report, you could go back and look. It refreshes your recollection. It refreshes your credibility. It helps you say, no, they never said that. That's frivolous. Poorly investigation reports are things that are just notes on paper. Those are not helpful to you. Unsigned, undated. If you're saying that you interviewed Bob, when did you interview Bob? Who was present when you interviewed Bob? The investigation report would have all of the relevant information. It's the who, what, where, whens, and why. What witness was it? When did you interview him? Who did you witness? Who did you interview? If you reviewed documents, what did you review? If you reviewed surveillance information, what did you review? The key really is to be contemporaneous with investigations and with everything. It's facts, not opinions. This person stated this, not I believe that this person stated this. So it's what did they say? Not well, I don't think that they're truthful because they're generally a whiny person. You are just doing the very specifics of this. And you don't keep your investigation reports in your personnel file. Those are segregated. So what do we do now? So what do we do going forward? First thing is we have to make sure that our employment agreements, our confidentiality provisions, our arbitration provisions, our severance agreements, those are updated. We have to make sure that if we have anything like mandatory confidentiality, arbitration, or non-disclosure, that those are revised so that those are not mandatory. We have to make sure that our severance agreements are changed to 21 days. And then there's very specific language that we have to put in there, so that the specific language is in there, that we update our training programs so that it has the information that we need regarding remedies, regarding what our processes are. If we have harassment and discrimination policies and we have a population that speaks, let's say Spanish or Polish or Italian as a primary language, that policy needs to be in that language. If we're doing training, we either need to have that individual trained in the other language or have a translator who is translating it in another language. It does not help, and we will lose if it's in English and that's not the primary language that people can speak or understand. We have to make sure that we do this, that we report the final judgments. Again, it's not that it's not pressing and not required. There's just going to be very few individuals on this call that have to do that. So paid sick leave is supposed to come in the fall. We will see if that actually does come. In a way, the impetus is coming up more because of everything that's going on with COVID-19. However, there is also a lot of other things that they are doing right now, but I just wanted to kind of apprise you of that, to think that that is also on the radar. And last but not least, update our application. Can't ask for salary history, and can't when we're interviewing say, what did you make at your last job? So we need to revise those. So I wanted to leave us about 10 minutes so that we could ask questions, whether it's about this or about something else, or you want to talk about planting or whatever. I'm here.
Thank you so much, Julie. That was a great presentation, very informative. We did receive one question through our chat box during your presentation. The state of Illinois has released training materials for a harassment training program. Have you reviewed those, and do they hit all the marks that are required?
Really good question. So yes. So the state of Illinois has released the training. They were supposed to release them in January, and then it became February, then it became March. And so finally, I think it was early April, though honestly that all kind of blends together at this point in time, because the February through May is like the lost month for purposes. But so they released the training materials. They are good. I am not telling you not to use them. But what I am telling you is that be very, very careful when you're using them. So like when you are conducting the presentation, you are required to hit those 4 spots, or the 4 things. Those are the only 4 things you're required to hit. You're required to do the remedies, the what your sexual harassment policy is, what sexual harassment is under federal and state laws, what your employer obligations are. But you are not required to spend 15 slides. It doesn't give a time in the legislation. So you're not required to spend 15 slides on this is how you call them, this is what you do. When we do the presentation and when other organizations do the presentation, you give that information, no doubt. I'm not saying you don't, but it is not 15 slides of focus. So just be really careful. And it's also not broken up between your employees and your supervisors. And remember, you're giving very similar information, but how you are giving the information is very differently. I want to scare the bejesus, a little bit, a healthy bit of fear, on my supervisors so that they take it seriously, so they don't just disregard it and walk past. I am not going to spend 5 minutes with my employees being like, so If your supervisor doesn't do anything about it, did you see their house at the last holiday party? You could have that house. I'm going to say that to the employees, but I am going to hammer that little more with the supervisor. So it's good as a base, but be careful when you're doing it, so that you are still using the 4 elements that you have to have, but how you present it and what you collapse is a little bit different, if that makes sense.
Absolutely. Thank you. We have another attendee who says, I'm really curious how other landscape companies are going to present, share, and implement the training given COVID-19 restrictions and the nature of our landscape business, as most employees are out in the field currently.
So I think that you guys could probably answer that better than I can. I could tell you what my landscaping clients are doing. This really threw it in a flummox, because what was initially going to happen is a lot of my landscaping clients were set to do this in March, like before everything heated up. Not COVID, but both actually, before your business really started swinging, because that is your sweet spot time. So before everything started swinging is when everybody was set to do it. And then everything happened with COVID, and then everything got locked down. So we weren't able to do this. So a lot of companies, what they're doing is they're having us, and this includes landscaping organizations, they're having us or somebody else present it and tape it, so that you'll catch some of the people who are in the field who are available that day, but then it's recorded. So then you tell the other individuals, okay, so on Thursday it's raining. Come in because we can't do anything because it's monsooning out. You're going to watch the tape of this, and you do it that way, so that you've got 2 presentations, one recorded for supervisors, members of management, and that includes your team leads, by the way. Your team leads, your crew leads, those would be supervisors, members of management. So you get as many people as you can, both physically and who are available the first time, and then after that it's recorded for other individuals, and then you could use that throughout the year.
Okay, great. Another question we have is, do you need a specifically qualified trainer to do harassment training? Are there videos that can suffice and be utilized virtually?
Sure. So no, there is no, yes, maybe so, like a really weird lawyer answer. So there are no specific requirements. You don't have to be an attorney. You don't have to be an HR professional. So there's no specific requirements. You don't have to hire a law firm. You don't have to hire, a sexual harassment training person. So there's no specific requirements for that. There are some, you know what? I take that back. I haven't seen a lot of the videos that are available yet. I know that there are some that are available because everybody was waiting for to do the official, like, published webinars and stuff like that, the videos. A lot of the organizations were waiting for the model training to come out to make sure that something wasn't added in there. And I haven't seen if there's anything that's good that's come out since then. There are a couple organizations that do good stuff. So yeah, so you could do it, like I said, like either you can have somebody come in and do it one. Now, what you need to make sure that you do, and I didn't mention this before, so I apologize, is it can't just be a generic video. It has to be congruent to your policies and procedures. So it could be a generic presentation that is adapted. So a lot of times you could pay for whatever presentation, whatever program, presentation, whatever program from a company, and they will insert your policy and procedure in there. So if it's, if you receive a report of harassment and discrimination at ILCA, contact Anne Marie. And if Anne Marie is the individual you're complaining against, then contact Scott. That needs to be in there. This is our policy. We have a 1-800 number. So because everybody's policies are different. So as long as the policy or procedure or the program that you're using could drop and drag, and they do, your policies and procedures in there, you're fine. That was a really long-winded answer for yes.
Good. I think we answered it well. We have about 2 more minutes if anyone else has any questions. Or Julie, is there another question that you see frequently come up during these conversations?
So, I mean, I think the biggest question that I get, and even though I already answered this, that you will get again is, but there's only 5 of us and we're related. Do I have to do this? Yes, everybody has to do this. The other question that I get a lot is, well, what if they've already left? If they've already left, you can't do anything about it. They're gone. But that's why for seasonal employees, it's really hard to, a lot of times the emphasis is to wait till the end of the season when things start dying down. But the problem is that, as you guys know, we have turnover, and we have a lot of turnover in certain, in certain of our organizations. You've already lost those individuals. And when the IDHR comes and looks for your, like when they say, did you do training? They're going to look and say, well, how many employees did you have this year? Not just did Bob get trained or did Jose get trained, but did you do training for everybody? You have 50 employees come through and you only trained 30 of them. Why? Now, this year, I think that there will be a little more understanding because of what happened with COVID, but I don't want to bank on that, right? Like, you don't want to bank on that. So if you can do the training in the beginning, and now we're already in the season, right? We're already halfway through the summer, but as quickly as possible before you lose people, which is why having like some type of recorded thing helps. That's helpful because you don't get the excuse of, well, I scheduled training on December 31st, and I'm sorry that the harassment occurred on April 15th, but they were going to get trained, type of thing. Particularly if what they say is, but I didn't know where to go. That one's hard.
Wonderful. All right, that wraps up our webinar today. Again, Julie, thank you so much for your time, expertise, and knowledge on this topic. Her contact information is on the screen, and we will be sharing it with webinar attendees. If you have any questions for her, a recording will be made available within a week of this webinar training. And have a wonderful day. Thank you so much.
Thank you.
Thanks, Julie.